Parviz Jarabi, attorney at law, have been practicing for over 20 years. Our office is located by San Francisco Airport, specializing in employment law. Today's topic, whistleblower protection in California. In California, a whistleblower employee is protected under the law from any retaliation by his or her employer. So what is a whistleblower? A whistleblower is an employee who discloses information to a government or law enforcement agencies or person with authority over the employee, or to another employee with authority to investigate, discover, or correct the violation, or the non-compliance, or an employee who assists with an investigation and provide information to or testifies before a public body conducting an investigation or hearing, where the employee has reasonable cause to believe that the information discloses a violation of a state or federal statute or a violation or non-compliance with a local, state, or federal rule or regulation, or with reference to employee safety or health, unsafe working condition, or work practices in the employee's employment or place of employment. A whistleblower can also be an employee who refuses to follow his employer's instructions to participate in an activity at the direction of his or her employer that would result in a violation of a state or federal statute, or a violation of non-compliance with the local, state, or federal rule or regulation. In California, the law protects you from your employer's retaliation against you for coming forward to report suspected violations of law, regulations, or public policy. Even if you turn out to be wrong, you still cannot be retaliated against as long as you reasonably believe your reports. For example, you're protected for reporting suspected criminal activity by your employer to government or law enforcement agencies, a suspected violation of law or regulation to a supervisor or other persons at your employers who has the authority to investigate the violation, a wage and hour law violation, or other labor board complaints to the labor commissioner, or economically wasteful, incompetent, or ineffective activities to the California state auditor if you are a public employee. Your employer's retaliation against you can be extreme by terminating your employment. This could be done in two ways: either your employer firing you or forcing you to quit by making your working condition so intolerable that you have no choice but to quit. Your employer retaliation can also be indirect, such as demoting you, issuing you an unfair write-ups, refusing to promote you to a higher position, or giving you a raise when you deserve it, or deny you the access to training opportunities so you can do your job better, or even threatening you that you will turn you into a U.S. Immigration and Customs Enforcement, ICE, if you make a labor complaint. Just know that you have a right under California whistleblower protection from any retaliation by your employer for blowing the whistle. If you have any question on this topic, please contact my office for free consultation. Please be sure to like and subscribe and turn on your notification.